observant, non-observant, everything in between. 3 words: tzedek, tzedek, tirdof. Justice, justice, thou shalt pursue. Okay, which sounds great. It sounds Jewish. It sounds like God telling us to do the right thing. If I went around the room, which I'd love to do, I just don't have time, there are too many of you, and asked you, what do you think that means? Justice, justice, thou shalt pursue. So you maybe throw out and say you should be honest, you should be, I don't know, righteous, you should be fair, you shouldn't cheat, you shouldn't lie, you shouldn't steal. And I will tell you that all those things are right answers with respect to the way you should and shouldn't act. But there are many other laws in the Torah that cover all those things. There is a law against stealing. There is a law against cheating. There's a law that you have to be honest. There's a law you have to be righteous in judgment. So what exactly is tzedek, tzedek, tirdof? Justice, justice, thou shalt pursue. Now, if you stop and look and take a second and look at the words, you notice something interesting. It's repeated. It's tzedek, tzedek, tirdof. In English, justice, justice, thou shalt pursue. Now, God is not Shakespeare. God's not saying, you know what? I think it'll be catchier. Instead of just saying, you should pursue justice, let me go with justice, justice. It's punchier. You know, God's God. He's got a reason. So he's trying to get our attention when he punctuates something like that. Number 2, even more compelling, is that he uses a very interesting word, which is tirdof. Tirdof is the word for pursue, but it's a particular type of single-minded pursuit. A rodef, a pursuer, is a person who is chasing after someone else to kill them. That person is not chasing after them to say hello. They're not chasing after them to ask them if they just saw the last episode of Succession or watched the playoff game last night. They're trying to kill someone. That is a single-mindedness of purpose. You don't play around with a rodef. So God could have chosen all sorts of different verbs. He could have said, justice, justice, thou shalt seek, tidrosh, or justice, justice, thou shalt do, justice, justice, thou shalt find, make happen. But he went with a very, very strong verb. You got to pursue it like a rodef, like you're going to kill somebody. Go after justice with a single-mindedness of purpose. So if I had to distill it to one answer, it would be difficult to do. The Talmud actually has a little bit of debate as to what exactly the answer is. And there is one commentator who is the greatest of all the commentators. His name was Rashi. If you haven't heard about him, his name is it's an acronym for Rabbi Shlomo Yitzchaki, who was writing in Troyes, France in the 1000s. Jewish population of about 100. How he was able to do this, I don't know. He wrote his magnum opus, a commentary on the Torah, in addition to a commentary on the Talmud. And he is I would say, the father of all commentators. So he has one explanation for what these words mean, and I guarantee you'd never guess this. He says, so what it means is, halach, achar, beis din, yafa. You should pursue the best beis din. Okay. Now he's quoting one of the opinions in the Talmud, and the Talmud explains what that means. What does it mean, the best beis din? When I was a baby lawyer and I wasn't quite as prepared for court as I am now, I would have said to you, and if you would have said to me, what's the best court? I would have said, that's an easy one to answer. The one that has a little stand where they sell kosher snacks, because there are some courtrooms that have them, some that don't. And the ones that have them literally saved me sometimes, because I'd show up for a 9 o'clock appearance thinking it was be an hour. And the next thing you know, the judge decides to send it to turn into a settlement conference. And we have to wait for the adjuster to show up, and lawyer needs authority, or he's got another case to cover. Next thing you know, it's 5 o'clock. I didn't bring lunch along. So that's what I would have said is a great court. The Talmud and Rashi said it's not what it means. What it means is you should seek a court that has the judges on it that are most likely to give you the correct opinion. Okay. And the Talmud cites like some very, very well-known sages, like they had courts, and they were, because of their incredible mastery of Jewish law, they were most likely to give you the right opinion. So think about that. 2 litigants, and they're going to go to the court that's most likely to give them the right opinion. I'm a lawyer. Clients come to me who have been injured in very serious accidents, typically catastrophic accidents, people who have lost limbs, lost loved ones, lost bodily functions, and not once, and I've been doing this a long time, I switched out of big firm practice into the family business, personal injury law in 1996. So it's a long time now. Not once have I had a client come to me and say, I want to hire you, but I want you to go to the best court, the one that's going to be most likely to get it right. You know what my clients come to me for? My clients come to me for one thing. They want money. And they want to know 2 things. They want to know, how much am I going to get, and how quickly am I going to get it? And they want the most amount of money possible. And when I choose a court on behalf of my clients. I choose not the court that's most likely to get it right, but the court where it's most likely that my client is going to win and win the most significant amount of money. Exactly the opposite of what the Torah is telling us to do. Now you'll say to me, what's going on? I thought you were a Jewish lawyer and you got one of those like fashion statement, beanies on your head. And the answer is that when I'm representing my clients, I'm representing them in a different venue. I'm not representing them in the Beit Din, I'm representing them in the secular courts, which is entirely different. So let me give you an example of how this differs. I had a case once where a horrifying case, a fellow was in a nursing home, and as a result of shock the conscience level negligence, he died, just beyond imagining. I don't want to tell you the details because some of you will have trouble sleeping. It's that horrifying. So a friend recommended one of the surviving sons-in-law, who called me up, told me the situation. Are you interested? I said, absolutely. He said, would you mind coming out to meet my family? This was, back in the pre-pandemic days when people would actually get together and meet in person. You can remember those days. So I drove out to his very nice home in Westchester. He was there with his wife and her two sisters. And I said, okay, let me get some information. Where do you live? Obviously, Westchester. Where does the other sister live? Westchester. Where does the other sister live? Westchester. And other siblings? Yes, we have a brother. Where is he? He might be here later. We're not sure. Where does he live? Bronx. Okay. Was there a will? No will. I said, okay, so I just want to tell you at the outset, your brother will be the administrator. The son-in-law who invited me says, can we just take a quick break? We're 5 minutes, 10 minutes into the meeting. I said, sure. He walks me outside to his very fancy circular driveway. And he says, listen, I love my brother-in-law, sweet guy. He's an alcoholic. He's a drunk. There is no way he's going to be the administrator. I'm not telling you it has to be my wife. It could be her or one of the sisters. Absolutely no way is he going to be the administrator. I said, let me explain to you something. He is going to be the administrator. Let's go back inside and I will explain. And I went back inside and I explained. Under New York law, when you're choosing a court, you have choices. If Smith rear ends Johnson, and Smith lives in Brooklyn, Kings County, and Johnson lives in Staten Island, Richmond County, you can file in either one of those counties. You can always file, with some exceptions, if a municipality is involved, but typically you can file wherever the plaintiff lives, person who got injured, or wherever the defendant lives. There's a quirk in the law that says the following. In a death case, if there's a will, the executor is already named. And so wherever the executor lives, that's where you can file, or you can file where the defendant lives. But if there's no will, then there's no executor named. You can choose an administrator, and wherever that administrator lives, you're allowed to file there. So I explained to them, Westchester is an extremely unfriendly county to plaintiffs. The Bronx is an extraordinarily friendly county to plaintiffs, probably top 3 in the nation. And the difference between filing in the Bronx and filing in Westchester can sometimes be as large as 0. And they said, what do you mean 0? I said, oh, I'm sorry, I forgot to tell you where the 0 is. The 0 is at the end of the number, meaning a case in Westchester that could settle for $100,000 or get a verdict for $100,000 could conceivably be $1 million case in the Bronx. I said, my job is to maximize recovery for you. Your brother, as long as he can sign his name, which I'm sure he could sign his name, is going to be the administrator. And they agreed. Now that is the exact opposite of going after the court that's most likely to get it right, because we have very different systems and we have very different goals, okay? And the difference in goals is the following. In the secular world, in the courtroom, which is where I practice, our goal is one thing, it's resolution. We can't have ties. The judge will send the jury out if they can't agree. He'll send them out another day, send them out another day. Guys, negligent or not, you got to tell me yes or no by a vote. In my world, if it's in the criminal context, guilty beyond a reasonable doubt or not. Is he guilty or is he acquitted? Okay. And so in my world, and now once you've decided, is the defendant negligent? How much money? We can't decide. Go back another day. You got to decide. We need a resolution. In the Jewish court, in the Beit Din, we're not interested in a resolution. We're interested in the truth. And sometimes we can't get at the truth. And so I'll give you an example of this. There's a classic case in the Talmud. It's one of the first cases that children learn when they start learning the Talmud, or, around bar mitzvah age. And the case is the following. It's called Shnayim Ochsen. It's 2 people come to court, and they're both holding a talis, a talit, and they're each holding it by the edges. So each one has, have you ever seen a talit? There are little like fringes on the edges. So each one's holding onto the fringes. And each one says, I found this talis and it's mine. Each one. The court does the following. It administers an oath to both of them, a rather ingenious oath. They both swear that I own no less than half of this talis, which according to both of them is true, right? Each guy thinks he owns the whole thing, so he owns no less than half. And then the court splits it. They could choose. Either they cut it in half. I don't know what they're going to do with half the talus, or they sell the talus and each one takes half the money and they go home. We have a resolution. But what if two guys come into court, each holding the fringes on the edge of a talus, and each one says, I wove this talus myself and it's all mine. The other one says the same thing. Now we know one of them's a liar. Okay. In the first case, it was possible for them both to own half of it. Why? Maybe they found it. And when they found it, they both jumped on at the same time, finders keepers, and photo finish is unbelievable. It's a tie. We went down to the millisecond. They actually grabbed it at the same time. So it's humanly possible for them both to own half. In the second case, one of them is a gigantic liar. It's not possible for them each to have woven it. So we can't let them take the oath of I own no less than half of it because one guy's lying. We throw them out of the courtroom. Sorry, guys, we cannot give you a resolution of this case because it will violate the truth. In my cases, every single case, just about, we have a liar in the courtroom. Classic intersectional collision. The police report says vehicle number 1 states I was driving through the green light. Vehicle number 2 came through the red light and hit me. Vehicle number 2 states I was driving through the red light and vehicle number 1 ran the red light and hit me. Somebody's lying. I don't know who's lying. They're both going to go into court. They're both going to swear to tell the truth, the whole truth, and nothing but the truth. So help me God, or affirm. And the first person is going to say, I had the green light. Next person's going to swear, I had the green light. Somebody's lying. Doesn't matter. We tell the jury. The judge will tell the jury. You have heard different versions of events. You are the fact finders. You are going to determine credibility. You are going to decide. We would not let that happen and abate them. We would not let people take conflicting oaths, knowing that there's a liar in the courtroom. Okay. So I'm going to give you an example now, spend a few minutes on this, of a case that I had that I don't know if any of you are lawyers, but even if you're not, I'm sure you've watched enough TV shows. You could litigate a lifetime and never see a case like this. It's that bananas. So we had the following case. A young man was walking underneath a construction scaffold at a construction site. And the next thing he knows, somehow some piece of construction debris went through the scaffold, hit him in the eye, and partially blinded him in one eye. Very serious case. So he hired us, and we went out and we sued. Again, if I was here in front of a live audience, I would throw this question out to you, but I'll just answer it for you. We went out and sued everybody because that's what we do in a case like that. You ever see the signs that you know in many states they're required, many cities they're required, in New York City certainly it's required. If there's a construction site, it will name the owner of the building, the general contractor, often it'll have the subcontractors, the architect. We sued everybody. How are we supposed to know who was responsible? So the owner and the GC and every sub that had filed a work permit as of that date, that work date, we sued. We had 9 different defendants. We sued the defendants. They put in their answers. We send out our discovery requests, the standard requests. We want to know, tell us what you were doing on that date. Give us your employee roster. What equipment were you using? Were there any reports of an accident? Did you see our client? The standard, whatever, 10, 20 questions. We send it out to the 9 defendants, and some answer right away, some don't. My brother's handling the case. He sends a letter to the 3 or 4 that didn't answer. Hey, I sent this to you 30 days ago. It's overdue. Please send an answer. The next 3 do answer. 1 doesn't answer. So of the 9, 1 of them never answered the discovery requests. So my brother files a standard motion. He asks the court to strike the defendant's answer. Now, let me explain what that means. If a court ever strikes a defendant's answer, it's an incredibly rare relief to be granted by a court. The case is over. Against that defendant, we go straight to an inquest in front of the judge or a jury, and the judge or the jury puts a number on the case. They can no longer defend. If your answer is stricken, you cannot defend, no defenses. It goes straight to damages. So it's devastating for a defendant. Judges never, ever like to grant default judgments. So my brother files the motion. We show up on the hearing date. My brother says, Your Honor, I sent the discovery requests. 30 days went by, they didn't answer. I sent the letter. I waited another couple weeks, no answer. I filed the motion, strike their answer. Judges, listen, just take it easy, okay? What do you have to say for yourself? The defense attorney says, Your Honor, the dog ate my homework. I don't know what excuse he says. He comes up with some excuse. Judge says, fine, write up an order. I'm going to give you another 30 days, okay? All right, expected. He gets another 30 days. 30 days come and 30 days go. He doesn't respond. My brother can't believe it. So he files another motion saying, Your Honor, this is crazy. Strike his answer now. They show up. My brother says, we sent the discovery, didn't answer. We wrote a letter, didn't answer. We filed a motion. He showed up. You gave him another 30 days. He didn't answer. Your Honor, this is crazy. Strike his answer. Judge says to the defendant, hey, what's going on here? What do you have to say for yourself? He's right. I gave you another 30 days. Defense, I I was in, I don't know what, I was on a safari. My mother, my father, well, who knows, whatever, a medical emergency. Okay. He begs the judge. Judge says, okay, fine. Listen, I'm going to give you another 30 days. Okay. I'm telling you, you really better get it to him within 30 days. Okay. He says, somebody has to mute. Okay. Thank you. So he says, don't worry, Your Honor. Like, he'll have it on his desk, within 48 hours. Okay. So my brother says, Your Honor, when we write up the order, can I make it self-executing this time? Meaning that if he doesn't give it to me within 30 days, this time I shouldn't have to come back to you a third time. Can his answer be stricken? The judge says, you know what? Yes. Looks at the defendant. You better. It's like, don't worry, I'm going to get it to him. Okay. 30 days go by. He doesn't send us the discovery. The answer is now, it's a self-executing order. Stricken. He's done. We have won the case against him. All right. Why didn't he ever answer? I have no idea. My brother sends him a letter saying, look, we're moving for inquest. He sends in the request for an inquest so that we'll have it at the time of trial. He cannot defend the case. All right. While this was going on, this whole back and forth, which took obviously over the course of, more than 2 months, an eagle-eyed other lawyer for one of the other 8 defendants saw a scribbled note in the medical records and hospital records stating that the hospital had retrieved the piece of metal that went in this fellow's eye. So he writes us a letter saying, with a copy of that page of the medical records, hundreds and hundreds of pages of medical records, saying, look, the hospital apparently took the piece of metal. We'd like to examine it. And we say, okay, like, well, we can't, we'll call the hospital. We'll see if they still have it. We send the request. The hospital says, yeah, we have it. Why didn't they send it to us when we requested the medical records originally? I don't know. They had it in their separate room for pieces of metal extracted from people's eyes. Okay. They send us the piece of metal. We make an agreement with the other side. We're going to send it to our expert metallurgist. They're going to send it to their expert. We send it to our expert. They send it to their expert. Both experts agree. It's a BB from a BB gun. Nothing to do with a construction site. Unfortunately, somebody in the neighborhood must have been playing, some idiot was shooting a BB gun, hit him in the eye. Now, we have the ambulance call report. To this day, I absolutely remain convinced that this young man thought that he got hit from construction debris. The ambulance call says, that he was picked up from underneath the construction scaffold. He didn't know it was a BB gun. So now our case is over. There's no case. Can't bring a case against construction companies because there was a BB hit him in the eye. So the defense attorneys draft a stipulation of discontinuance to end the case. They send it to my brother to sign, and my brother signs it. But before he signs it, he takes his pen and he crosses out the name of one of the defendants. Which one? The one that didn't answer. Because we won against that defendant, he sends it back. He gets a call about 5 minutes later from the lawyer, the one who never sent in the discovery, saying, by the way, what's going on here? Why'd you cross out my client's name? The brother says, what do you mean? We won against you. We're going to inquest against you. He said, what are you talking about? It was a BB. That's a fraud. You can't continue the case. The brother says, fraud is a defense. You don't have any defenses. I can't discontinue the case. It would be malpractice. Imagine if I had waited 3 years and a day past the statute and then sued your client in a rear end hit when your client's clearly responsible. What would you do? You'd say, you wouldn't be able to bring the case. I said, exactly. So you use that against me. I represent a client. We won the case against you. Okay. The next day, a new adjuster shows up, or a week later, calls me. There's a new adjuster. Why? Because there's a new insurance company involved now. The lawyer's insurance company. The lawyer committed malpractice by not responding. The client had no idea that the lawyer never responded. He could have just responded by objecting. Just any response would have been fine. He never responded. So the malpractice, the lawyer's malpractice insurance carrier's adjuster calls me, says, Harry, listen, I know you. I don't know your brother. I've dealt with you before on cases. I know you're a straight shooter. I'm making a one-time offer. I'm not happy about this. I think it's outrageous, but I understand where you're coming from. I spoke to your brother. He said $1 million. He's not negotiating. I'm offering you $500,000. I know your client doesn't live in the greatest of areas. It could be a life-changing amount of money. Get back to me, okay? I speak to my brother. My brother says, listen, I spoke to our appellate counsel. He said, we're going to win. I told him $1 million. And that's a reasonable number. I call him back. He says, okay, that's it. I'm not offering another dollar. We go in front of the judge. The judge awards the $1 million that we asked for. They appeal. We go to an appellate court. Our appellate attorney, one of the finest appellate attorneys in New York State, argues the case. The appellate court says, fraud is a defense. You win. It's over. And they're obviously disheartened. So they file a motion to the Court of Appeals in New York. The Court of Appeals in New York works like the Supreme Court of the U.S. in that they decide which cases to take. It's not automatic. Lower appellate courts have to take every case. The Court of Appeals chooses which cases to take. Our appellate attorney says, don't worry, they're never going to take it. This is open and shut. We get a letter in the mail from the Court of Appeals saying, we have granted cert. We're taking the case. Uh-oh. That means at least one judge has a problem with this. So we go to the Court of Appeals up in Albany. My brother goes with our appellate attorney who argues it. And not one, but two judges say that it is true. When an answer is stricken, there are no defenses. But fraud is a different type of defense. Fraud means there was never an underlying case. Now, we have no reason to suppose that the client or Rothenberg firm knew that it was a BB. No one knew it was a BB. We're sure they filed it in good faith. But fraud means there never was a claim. So we would overturn it. We would wipe out the default and let him defend by alleging fraud, and at which point, obviously, we would drop the case. Three judges say a stricken answer is a stricken answer is a stricken answer. Fraud is a defense like any other defense, can't defend. At the time, I think the million had gone up to with interest something like $1.2 million, $1.25 million, because interest was ticking. We end up, they had to pay it. They had to pay every penny, $1.25 million. I begged the client to do a structured settlement to get the money over time. Wouldn't listen to me. He had it all figured out. And a day later, I got a call from my receptionist from BMW of Manhattan asking for me by name. They wanted confirmation that the check that I had signed, was legitimate, and that our client did just receive whatever it was, $800,000 because he was driving off with like $100,000, BMW. Okay, that was the postscript of the story. That case can absolutely, it did happen, very rare and bizarre case under secular law, because we're interested in resolution, and we need discovery deadlines to have teeth, and lawyers have to learn their lessons. They have to respond to discovery. I cannot imagine that in a bait din that case could possibly result. I'm sure there are rules. I'm sure there are regulations. I don't litigate there, but we're interested in truth. And the underlying case there was we ended up recovering on a case that never happened. I have no qualms about it because that is the law of the land. And the answer was stricken. And I felt very bad. I mean, it was an awkward case and I felt terrible for the lawyer, but that's the law. It's a completely different regime. I want to give you another example of this. Okay, a different example. So I have I'm just looking down at my phone because I want to see if I can find a picture to show you while I'm telling you the story. I apologize, I should have found it earlier, but I should be able to find it relatively quickly. So 2 winters ago, not this past winter, the winter before, a friend of mine called me and told me that he had slipped and fell on the ice at a mutual friend's home, another very close friend of mine. And he asked me whether I'd be interested in the case. So I asked him for what had happened. He told me what had happened. He fell, he shattered his wrist, while walking on. I found the picture. So I said to him, look, I need you to give me the information with respect to the following. Okay. And I walked through the law with him. I would normally not do this, but I knew him very, very well. And I thought it was important to do this. And so I did it. So I explained to him the following law. This was a New Jersey case. So New York law is different. So I'm just going to explain to you how New Jersey law works, the way I explained it to him. New Jersey law works as follows. If you slip and fall on ice on a person's property, meaning the steps, let's say, leading out, I was very familiar with the house, it was a mutual friend, the steps leading from his front door to the sidewalk, and it was as a result of snow and ice that was either uncleared or not properly cleared, you absolutely have a valid case, and you could sue him successfully. However, if you had left the steps, even if it was the first step off the steps, onto the public sidewalk, and you put your foot on the sidewalk, and that's when you slipped on ice that, maybe he should have cleared it, there is absolutely no case. You cannot sue a homeowner for failing to properly shovel in New Jersey. You could sue a store owner. If it's a commercial property, then you can. It's a different law, but not a homeowner. And you can't sue the municipality. You are out of luck. New York City is different, but in New Jersey, that is the law. I said to him, so let me know, where'd you slip? Did you slip on the steps or did you slip on the sidewalk? He said, before I answer that, I have one question. What did he ask? The obvious question. I told you what everybody always wants to know. How much will I get? I said, listen, how am I supposed to tell you that? I haven't seen a medical record. I'm not familiar with the injury. He said, look at your phone. And he sent me, I'll try to hold this up so you can see it. He sent me the following picture on WhatsApp, and I will share this with you. This was the picture, if you can see it. Okay. That is a massive fracture with you'll see the plates and the screws that are in his wrist. He had shattered his wrist. It's a horrible, horrible injury. Okay. So I said to him, I don't normally do this, but you're a friend. And so I'm going to do it. I said, if you don't have any future surgeries, then you're not talking about $1 million case. If you need multiple future surgeries, you have bad recovery, you could be looking at a 7-figure case. So, but I'm going to assume the best case scenario that you're only going to need one more surgery, which you likely will need to remove the hardware. He said, that's right. You told me that already. I said, so I'm going to assume it's going to be 2 surgery case with a recovery that will involve the likelihood of osteoarthritis You'll always know before anyone else when it's going to rain or snow. You'll always know that. You're always going to have some pain, some limitations. I'm very familiar with this injury. So you're already looking at, even without any significant additional treatment, a very comfortable six-figure case. And the first number is crooked, meaning it's not a one. Okay. You're talking about somewhere 3, 4, 5, 6, maybe 7, $800,000. Okay. Where'd you slip? Okay. Now, this is a pretty big question, right? All he has to do is say, I slipped on the steps, and he's looking at 2/3 of 3, 4, 5, 6, 100,000. He's looking at hundreds of thousands of dollars. And he says to me, I slipped on the public sidewalk. Okay. And as I said, I would not do this with a stranger because it would be an overwhelming temptation. It would almost be like me saying, come on, work with me here. Just, I don't care where it happened. Just tell me it happened on the steps. But I know that he's a straight shooter, and he was honest, and he gave up hundreds of thousands of dollars. He said, I'm not gonna lie. I slipped on the steps. Now, in our world, and this is where the rubber meets the road. Okay, as somebody who is tries to be very, very careful about straddling the line, about being observant while out in the secular world. For me, it was really a defining moment. And the reason it was a defining moment is that I know somebody warned me, a rabbi warned me about this before I went to law school. You have to be very careful because in law school, they teach you how to lie. And I was like, okay, whatever, he's a rabbi. It sounds like something a rabbi would say. And now, having gone to law school, I know exactly what he's talking about because this is a classic moment. I mean, you tell me, what are 99% of lawyers and 99% of clients going to do in that situation? You're looking at a case that is a very substantial case. All he has to say is, I slipped on the steps. He could just say the last step. What's the difference between the last step and the sidewalk? 6 inches? What's the big deal? Hundreds of thousands of dollars. Sometimes it can be millions of dollars at stake. We have to be careful not to go over the line. And so I'm always mindful that even though I am typically not running tzedek tirdov after the right court, that I'll have the right decision, but that doesn't mean that I can discard all the other laws about lying, about cheating, about stealing, about cutting corners. I still have to be very, very careful about being honest while I'm in that other arena in the outside world. Now, I want to tell you is that for us, to the extent that we're ever litigants, God forbid, and you may wonder, so what happens if it's a Jew versus a Jew? Like, when exactly, if I were you, I'd be wondering, so like, when do you decide to go to court? When do you decide to go to Beis Din? So it's very interesting. There's a law that a Jew is not supposed to sue another Jew in secular court. If a Jew has a claim against another Jew, they're supposed to go to Beis Din, and they're supposed to go to the right Beis Din, the one that's most likely to get the right answer. So you'll say to me, well, then how do you have cases sometimes where Goldberg rear ends Greenberg, or Cohen gets run over by iceberg? And I saw somebody wrote, what's Beis Din? Beis Din is the Jewish court. It's a court composed of halachic decisors, people who are typically rabbis, but not just any rabbi. Just the fact that you're a rabbi doesn't mean you can sit on a Beis Din. It means people who have mastered the laws governing whatever area it is that has to be adjudicated. Typically, it's laws of damages, it's contractual laws, it's business disputes. So it's composed of a group of rabbis. Typically, 3 would sit on a Beit Din, and so they are well versed in these laws. And so the dispute comes before them. They listen to both sides, and then they render a decision. So the answer is for why I am allowed to take a case of Jew versus Jew is that I'm not going after the Jewish person's wallet. I'm going after an insurance company. So as long as there is insurance behind it, they're the real litigant. I'm not. Yes, I have to name the Jewish defendant in order to bring the case, but they're a defendant in name only. They're the nominal defendant. They're not going to pay anything. I'm not trying to take anything from them. I'm only trying to take money from the insurance company. There are certain instances where there might not be insurance. There might be a gap insurance. That's the topic for another talk. We could talk about it another time. So we've done the right thing, and we've decided, let's say I have a dispute with a fellow Jew and there's no insurance involved. And so I'm going to go to the Beit Din, and we both decided we're going to go to the right din, Beit Din. Still not enough. How do I know that? There's another passage in Torah that says that you have to do what is straight and good in the eyes of God. And Rashi again says, what does that mean? It means compromising and going beyond the letter of the law. Okay. And there's a section of the Talmud that says that at one point in time when Jerusalem was overrun and it was destroyed, the reason it was destroyed was because they did not judge themselves according to the laws of the Torah. So the Talmud asks, say, well, what did they use? They used like secular law to judge their own internal disputes. And Talmud answers and says, no, they used Jewish law, but they didn't go beyond the letter of the law. Because that's really what we're asked to do. We're asked to go beyond the letter of the law. Famously, there's a famous rabbi called the Chafetz Chaim, and occasionally he had business dealings, and he had an account that he called his Reeve account, which is a word for arguments. And anytime there's an argument, he would just dip into that account and just pay it, go beyond the letter of the law. And I will tell you that this is something to just keep in mind. It should never happen when you're in a dispute. I had a situation involving two Jewish clients. And over the course of the case, there was a massive financial dispute, as can sometimes happen. Sometimes you'll have let's imagine a family situation where there's a question as to how to divide the funds. Doesn't happen that often because typically they're divided by statute. And if they're children, they would divide equally. But sometimes you could have multiple people who die. There are occasions, or how much do we give to the parents and how much do we give to the children? There are certain times when it can be a question as to how to divide it, and it's not through statute. And typically the family sits down and decides, and it led to a war. It was one of the most horrifying things I've ever seen in my career, a war between family members. And I remember talking to, one of the clients saying that, he kept thanking me. We got an extraordinary sum of money on the case. And he said, I cannot thank you enough. I can't believe you're able to, achieve, this much money on behalf of my family. But it's bittersweet because I gained all this money, but I lost my relationship with, I don't even want to say what the family member was, what the relationship was. And I sat and I begged him. I begged him and begged him and begged him. I said, listen, I'm going to talk to you now. Not as your lawyer. I'm just going to talk to you as as a friend. Okay. There's a very powerful story told, and the story is told as follows: that when the second temple was being destroyed and the Jews were going into exile, God just got so fed up. He's like, that's it. I'm done with them. I'm done with them. So the prophet Jeremiah, I don't know how he did this. This is the way the story is told. He's sort of he called out to heaven, like, Abraham, please pray for the Jews. And Abraham prayed for the Jews, and God was like, I'm sorry. Okay. It's pretty big to say no to Abraham. Okay. Isaac prayed, come on, I have the human sacrifice. You know what? Sorry. Jacob prayed. Sorry. Okay. And Sarah prayed, at Jeremiah's behest. Sorry. And then Rebecca prayed. God said, sorry. And then Leah prayed, and God said, sorry. And Rachel said, God, can I have a word with you? Rachel, Mama Rachel, of course. Okay. What do you want to say? But I'm telling you now, I'm not saving them. Okay. Okay. Just hear me out. You know what happened? I was supposed to marry Jacob, and my father on the wedding night switched my sister. And you know that Jacob had made up signs for me because he knew that my father, Lavan, was the trickster, and he might try to pull a stunt like that. And I didn't want my sister to be embarrassed. I wasn't jealous of her. So I gave her the signs. I didn't know he was going to work another 7 years to marry me. I wasn't jealous of my sister, and I let her marry me. Now, I'm just flesh and blood. So I'm just asking you, you're God in heaven. Don't be jealous of the other gods that they worship. Will you please let them go? And God said to her, you know what, Rachel? You just saved the Jewish people, okay? By reminding him of how she gave up her right. What do you mean, right? What do you mean, Dad? Yeah, listen, sis, I love you, but I'm not, I didn't want my sister to be embarrassed. I wasn't jealous. So I gave up the signs so that she'd be able to marry my husband. And so what I begged him to consider, and I didn't follow up with him, wasn't for me. I'm not a yent. I didn't ask him. This was in the summer when this was happening. I said, I know how aggrieved you feel, because it was pretty clear that the other family member was acting outrageously. And he knew that, and I knew that. I said, so, but just, I said, I'm jealous of you. He said, what do you mean you're jealous? I said, because if you can stand on Yom Kippur and say, God, you know how outrageous it was. You know what was done to me. You know how they reached into my pocket. You know how they made unreasonable demands. I forgive them. There is nothing you can possibly do that is more powerful than that. Nothing more powerful than to say, and therefore, God, when I'm standing here today and you're deciding, as we say in the prayers, who will live and who will die, who will be rich, who will be poor, who will be, have a peaceful life, and who will live a life of all sorts of travails, who will have difficulties and who won't. I was not jealous. I gave in. I'm asking you to please, forgive me. And it's unbelievably powerful. So I finish with that. I'm supposed to finish by 9:30. So I have 2 minutes for questions, or if not, everybody can, start your evening a couple minutes earlier. And as always, thank you very much for listening. I'll let Rabbi Lewis send it to you. I do a short, like a 3-minute long video. I try to get it out every week on the Torah portion of the week or on the Jewish holidays. Much shorter than this talk. As I said, it's 3 minutes. So feel free to tune in. I'll ask the rabbi to send it out to you. And thanks for listening. And I'm happy to stay on a few minutes if anybody has any questions. Otherwise, be well and good luck in your careers and Jewish journeys.
Anyone, don't be shy. Don't be shy, guys. Okay, looks like they're shy.
Very welcome. All right.
Okay. Thank you very much, Harry.
You're very welcome.
I will share the link. I'll share it on the chat. And everyone have a great week. We will see you all back next Wednesday night.
Take care, everybody. Be well.
Thank you.
Thank you.
Thank you.
Very welcome.